Now, the nature and kinds of contracts. The law contract is the foundation upon which the superstructure of modern business is built. It is common knowledge that in business transactions, quite often promises are made at one time and the performance follow later. In such a situation, if either of the parties were free to go back on its promise without incurring any liability, there would be endless complications and it would be impossible to carry on trade and commerce. Hence, the law of contract was enacted, which lays down the legal rules relating to promises, their information, their performance, and their enforceability. Explaining the object of the law of contract, Sir William Anson observes the law of contract is intended to ensure that what a man has been led to expect shall come to pass, that what has been promised to him shall be performed. The law of contract is applicable not only to the business community but also to others. Every one of us enters into a number of contracts almost every day, and most of the time we do so without even realizing what we are doing from the point of law. A person seldom realizes that when he entrusts his scooter to the mechanic for repairs, he is entering into a contract of bailment, or when he buys a packet of cigarettes, he is making a contract of the sale of goods, or again when he goes to the cinema to see a movie, he is making yet another contract, and so on. Besides, the law of contract furnishes the basis of the branches of mercantile law. The enactments relating to sale of goods, negotiable instruments, insurance, partnership, and insolvency are all founded upon the general principles of contract law. That is why the study of the law of contract precedes the study of all other subdivisions of mercantile law. Unit objectives: understand meaning of the terms agreement and contract. Learn the essential elements of a valid contract. Be clear about various types of contracts. The Indian Contract Act 1872, 1872. The law of contract is in India is contained in the Indian Contract Act 1872. This act is based mainly on English common law, which is to a large extent made up of judicial precedents. There being no separate contract act in England, it extends to the whole of India except the state of Jammu Kashmir and came into force on the first day of September 1872. The act is not exhaustive. It does not deal with all the branches of the law of contract. There are separate acts which deals with contracts relating to negotiable instrument, transfer of property, sale of goods, partnership, insurance, etc. Again, the Act does not affect any usage or customs of trade. A minor amendment in Section 28 of the Act was made by the Indian Contract Amendment Act 1996. Scheme of the Act. The scheme of the Act may be divided into two main groups. 1. General principles of the law of contract. Specific kinds of contract. Contract of indemnity and guarantee, contracts of bailment and breach, contracts of agency. Before 1930, the Act also contained provisions relating to the contract of sale of goods and partnership. Section 76 1 to 3 relating to sale of goods were repealed in 1930 and a separate act called the Sale of Goods Act was enacted. Similarly, sections 239 to 66 relating to partnership were repealed in 1932 when the Indian Partnership Act was passed. Basic assumptions underlying the Act. Before we take up the discussion of the various provisions of the Indian Contract Act, it will be proper to see some of the basic assumptions underlying the Act. There are: subject to certain limiting principles, there shall be freedom of contract to the contracting parties, and the law shall enforce only what the parties have agreed to the bound. The law shall not lay down absolute rights and liabilities of the contracting parties. Instead, it shall lay down only the essential of a valid contract and the rights and obligations it would create between the parties in the absence of anything to the contrary agreed to the parties. Expectations created by promises of the parties shall be fulfilled, and their non-fulfillment shall give rise to legal consequences. If the plaintiff asserted that the defendant undertook to do a certain act and failed to fulfill his promise, an action at law shall lie. Definition of contract. According to Section 2H of the Indian Contract Act, an agreement enforceable by law is a contract. A contract, therefore, is an agreement the object of which is to create a legal obligation that is a duty enforceable by law. From the above definition, we find that a contract essentially consists of two elements. First is an agreement, second is legal obligation. That is a duty enforceable by law. We shall now examine these elements in detail. First, agreement. As per section 2E, every promise and every set of promises forming the consideration for each other is an agreement. Thus, it is clear that from this definition that a promise is an agreement. What is a promise? The answer to this question is contained in section 2B, which defines the term when the person to whom the proposal is made signifies the assent. Therefore, thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. An agreement, therefore, comes into existence only when one party makes a proposal or offer to the other party, and that other party signifies its assent, gives the acceptance. Therefore, in short, the agreement is the sum of total of offer and acceptance. On analyzing the above definition, the following characteristics of an agreement become evident. Plurality of persons. Plurality of persons, there must be two or more persons to make an agreement, because one person cannot enter into an agreement with himself. Consensus ad adam. Both the parties to an agreement must agree about the subject matter of the agreement in the same sense and the same time. Legal obligation. As stated above, an agreement to become a contract must give rise to a legal obligation, that is a duty enforceable by law if an agreement is incapable of creating a contract. All contracts are agreements, but all agreements are not contracts. Agreements of moral, religious or social nature, example, promise to lunch together at a friend's house or to take a walk together, are not contracts because they are not likely to create a duty enforceable by law, for the simple reason that the parties never intended that they should be attended by legal consequences. In business agreements, and the presumption is usually that the parties intended to create legal relations. Thus, an agreement to buy a certain specific goods at an agreed price, example 100 bags of wheat at rupees 430 per bag, is a contract because it gives rise to a duty enforceable by law. And in case of default on the part of either party, an action for breach of contract could be enforced through a court, provided other essential elements of a valid contract as laid down in section 10 are present, namely, if the contract was made by pre-consent of the parties competent to contract for a lawful consideration and with a lawful object. Thus, it may be concluded that the Act restricts the use of word contract to only those agreements which give rise to legal obligations between the parties. It will be appropriate to point out here that the law of contract deals only with such legal obligations which spring from agreements. Obligations which are not contractual in nature are outside the purview of the law of contract. For example, obligation to maintain a wife and children, status obligation, obligation to observe the laws of land, obligation to comply with the orders of a court of law do not fall within the scope of the Contract Act. Salomon has rightly observed the law of contract is not the whole law of agreement, nor is it the whole of law of obligations. It is the law of those agreements which create obligations and those obligations which have their source in agreements. Essential elements of a valid contract. A contract has been defined in section 2H. An agreement enforceable by law. To be enforceable by law, an agreement must possess the essential elements of a valid contract as contained in sections 10, 29 and 56. According to section 10, all agreements are contract if they are made by the free consent of the parties competent to contract for a lawful consideration with a lawful object, are not expressly declared by the Act to be obeyed, and where necessary satisfy the requirements of any law as to writing an attestation or registration. As the details of these essentials from the subject matter of our subsequent units, we propose to discuss there in brief here. The essential elements of a valid contract: offer and acceptance. There must be a lawful offer and lawful acceptance of the offer, resulting in agreement. The adjective lawful implies that the offer and acceptance must satisfy the requirements of the Contract Act in relation thereto. Second is intention to create a legal relation. There must be an intention among the parties that the agreement should be attached by legal consequences and recreate legal obligations. Agreements of a social or domestic nature do not contemplate legal relation, and as such, agreement intended to create a legal relation and therefore is not a contract. Agreements between husband and wife also lack of the intention to create legal relationship and thus do not result in contract. Third, lawful consideration. The third essential element of a valid contract is the presence of consideration. Consideration has been defined as the price paid by one party for the promise of the other. An agreement is legally enforceable only when each of the parties it gives something and gets something. The something given or obtained as the price for the promise is called consideration, subject to certain exceptions. Gratuitous promises are not enforceable at law. Capacity of the parties. The parties to an agreement must be competent to contract, otherwise it cannot be enforced by a court of law. In order to competent to contract, the parties must be of the age of majority and of sound mind and must not be disqualified contracting by any law to which they are subject. Section 11. If any of the parties to agreement suffers from minority, lunacy, idiocy, drunkenness, etc., the agreement is not enforceable by law at law, except in some special cases. In the case of necessary supply to a minor lunatic, the supplier of goods is entitled to be reimbursed from their estate. Section 68. Free consent. Free consent of all the parties to an agreement is another essential element of valid contract. Consent means the parties must have agreed upon the same thing in the same sense. Lawful object. For the formation of a valid contract, it is also necessary that the parties to an agreement must be agree for a lawful object. The object for which the agreement has been entered into must be fraudulent or illegal or immoral or opposed to public policy or must not imply injury to the person or property of another. Section 23. If the object is unlawful for one or other all of the reasons mentioned above, the agreement is void. Writing and registration. According to the Indian Contract Act, a contract may be oral or in writing, but in certain special cases it lays down that the agreement to be valid must be writing and registered. 8. Certainty. Section 29 of the Contract Act provides the agreements the meaning of which is not certain are capable of being made certain or void. In order to give rise to a valid contract, the terms of the agreement must not be vague or uncertain. It must be possible to ascertain the meaning of the agreement, for otherwise it cannot be enforced. Possibility of performance. Yet another essential feature of a valid contract is that it must be capable of performance. Section 56 lays down that an agreement to do an act impossible in itself is void. If the act is impossible in itself, physically or legally, then agreement cannot be enforced by law. Not expressly declared void. The agreement must not have been expressly declared to be void under the Act. Sections 24-30 specify certain types of the agreement which have been expressly declared to be void. Kinds of contract. Valid contract. A valid contract is an agreement enforceable by law. Voidable contract. According to Section 2(1), an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. Consequences of rescission of voidable contract. Section 64 lays down the rights and obligations of the parties to a voidable contract after it is rescinded. The section states that when a person at whose option a contract is voidable resigns it, the other party thereto need not perform any promise there is content in which he is a promiser. Void contract. Literally, the word void means not binding in law. According to the term, void contract implies a useless contract which has no legal effect at all. There are reasons which transform a valid contract into a void contract as given in the Contract Act are as follows: superventing impossibility, subsequent illegality, reputation of a viable contract in case of contract contingent on the happening of an uncertain future, even if that event becomes impossible. Void agreement. An agreement not enforceable by law is said to be void. Obligations. A person who has received advantage under void agreement of contract that becomes void. Kinds of contracts from the point of view of mode of creation. First, express contract, where both the offer and accepting constituting in an agreement enforceable at law are made in words spoken or written. It is an express contract. Implied contract, where both the offer and acceptance constituting an agreement enforceable at law are made otherwise than in words by acts and conduct of the parties. It is an implied contract. In constructive or quasi contract. The term constructive or quasi contract is a misnomer. The cases grouped under the types of contracts have little or no affinity with contracts. Such a contract does not arise by virtue of an agreement expressed or implied between the parties, but the law infers or recognizing a contract under certain special circumstances. Kinds of contract from the point of view of the extent of execution. Executed contract. A contract is said to be executed when both the parties to a contract have completely performed their share of obligation and nothing remains to be done by other party under the contract. Executory contract. It is one in which both the obligations are outstanding, one on the either party to the contract, either wholly or in part, at the time of formation of the contract.